This next panel, the topic is demystifying CBD and hemp regulations. There's going to talk about what's really legal, which is a very popular question these days. It's not as simply answered as some may think. We're going to have John Robbins, who serves as the leader of Akerman's cannabis practice. He's going to be the moderator. James Horvath, co-founder and managing partner at Kaycha Group. Arby Barroso, founder of Green Roads. David Hasenauer, Chief Executive Officer of Greenpoint Research, and Gary Steed, National Project Manager of Perry Johnson Laboratory Accreditation.
Thank you. I guess I'll sit. Morning, everybody, and thank you for being here. My name is John Robbins, with the Akerman Law Firm. I head up the campus practice group. And for those of you who know the session that you came to see, this is Demystifying CBD and Hemp Regulations. Where are we legally? As most of you probably know, back in December of last year, the United States Congress amended the Farm Bill to remove hemp as a Schedule I substance, in fact, to remove hemp from the bill altogether, and hemp extracted products. Prior to that, and since then, there remains a great deal of confusion in terms of what is permissible, what is impermissible, how do we operate between states, how do we engage in cross-border transactions, what are the testing requirements, on and on and on. You can ask professionals, you can ask individuals in the industry, and the confusion persists. Luckily, we have an amazing panel here today. I'll go down the list, I'll let these guys each introduce themselves, tell you what they do, starting with James Horvath from Kaycha Labs.
I am James Horvath. I am James Horvath. Can you hear me?
I can hear you.
I'm with Kaycha Labs. Yeah. The Kaycha Labs has.
Here, James, let me give you this one.
I am James Horvath. I'm with Kaycha Labs. That's better. We have 8 laboratory locations in 7 states. We started here in Florida in 2016. And we provide testing for hemp and cannabis products throughout those locations. We do about 20,000 tests per month right now and deal with over 700 different companies throughout the United States that sell either industrial hemp converted to CBD or cannabis products that are sold legally.
Thanks, James. Arby is the co-founder of Green Roads, which is one of the largest and most respected CBD product manufacturers in the country. Why don't you tell a little bit about Green Roads?
Hi, good morning or good afternoon for some of you. My name's Arby Barroso. I'm one of the co-founders of Green Roads. We've been in business since 2013 when we incorporated. We've been able to grow the industry in Florida and outside of the states, and having to deal with certain regulations and rules from 2013 all the way to 2019. And we're the private partner for the University of Florida, so we've put about $1.3 million into research for the state, for farmers, for agricultural grows. So besides selling products, we're heavily involved on the legislative part. I know David and myself championed the bill, the SB 1020, which will help regulate the rules for the state and many other states that are actually looking at Florida to kind of follow that same guidance. So I'm proud to be here and discuss anything that you guys are interested in having conversations about.
Excellent, thank you. Next to Arby is David Hasenauer. David is the CEO of Greenpoint Research. Why don't you give a little background on you and Greenpoint?
Yeah, absolutely. So got out of the Army in 2013, knew I wanted to get in the cannabis industry. Went back to law school at Florida State, got involved with the Amendment 2 campaign. Decided I didn't want to do the political side of it, want to be in production. Me and some of my friends co-founded Greenpoint Research, and we are a biomass originator and processor, which means we leverage our proprietary seeds and germplasm to get acreage under management, and then do that first phase processing in bulk commodities to supply to individuals like Arby and deliver an identity preserved product to prevent product liability issues and those kind of things as we start to scale an industry to a real commercial, industrial size. Like you said, we work closely together to pass SB 1020, long background in policy, and excited to answer any questions that you guys have.
Good, we're going to try to stump you. And lastly, we have Gary Steed, who's the National Project Manager for Perry Johnson. Is it regulators?
It's Perry Johnson Laboratory Accreditation.
Oh, laboratory accreditation. My apologies. Gary was a late addition to the panel. Gary, why don't you give us a little bit about your background and tell us what Perry Johnson does?
Well, I'm a, can everybody hear me? Okay. I'm a University of Detroit Mercy alumni. I was an institutional bond broker back when everybody can remember the mortgage crisis. I actually did the opposite end and sold tail-end pieces of well-seasoned products because I didn't understand how people could be selling such product for good credit people with that much leverage. So I couldn't understand it, got out of that industry and said, what business can I get into where I can help people, provide guidance, because in the bond business you don't tell anybody anything. Where can I do that for free? I didn't need the money, so I said, where can I help people? Well, it happened to be laboratory accreditation, and I also deal with certifications as well. So we provided Perry Johnson Laboratory Accreditation, been in business since 1998, the registrar that handles certifications in food safety since 1994. The accreditation body handles the accreditations for testing labs to the ISO 17025 standard. It's an internationally accepted standard, the only internationally accepted standard that when you produce a test report, it must be accepted internationally. So that's why it's so important. We're part of the ILAC MRA signatory arrangement. 80 plus economies throughout the world accept our accreditation. And we're sort of sandwiched in between the regulatory side for the state agencies and the groups who must make sure the products are safe. So Kaycha and all those other labs that are out there that do cannabis testing, we accredit them, make sure their SOPs are correct, their data is defensible, their proficiency testing is up to the standards, that they follow the state requirements, and so forth. If anybody has any questions or needs additional guidance on either certification, whether it be ISO 9001, HACCP, GCMP, FSSC 22000, ISO 22000, BRC, SQF, you name it, I can probably provide you free guidance for you. I've got to be careful because I cannot consult because that's a conflict of interest for me. So if anybody needs me, I'm Gary Steed, I'm with PJLA, and I'm happy to help.
Gary, I'm glad to see that you made it from the shady streets of Wall Street to the far more transparent and honest, in my opinion, world of cannabis. And don't put your mic down yet, because I'm going to put you on the spot for the first question, which is the basics.
Okay.
Let's describe for the audience the distinction between, we all know, well, I don't know if we all know, but both hemp and marijuana are both species of the same plant. Cannabis would be the L. Can you explain to the audience the distinction between hemp and cannabis, at least in the eyes of the federal government, and whether that distinction is the same from state to state?
Well, we do our best to follow between all the states. The states give us the regulations that we must enforce. The easy way to look at it is if it's over 0.3%, you might have a problem if you don't have a Schedule 1 DEA permit to possess that. That's as far as we get into it, because we don't want to tell somebody, hey, listen, if you're dealing with sativa, it's this, or if you're dealing with the other, it's that. Because what's really important is that the THC content is below the required level. So we're more about our clients understanding the rules and regulations, making sure that they follow those rules and regulations. If we see that you're doing something wrong, we'll point that out. You get a nonconformity and have to answer that. But other than that, we try not to give the advice for those technical questions that are law requirements. We'll divert those to your own attorney to handle those.
So the big determining factor between hemp and marijuana is that critical 0.3% or less of THC content.
For us, that's correct. James or one of the other gentlemen here could probably give you a better answer because I'm not supposed to consult.
Well, we'll get into it tonight, and we have some further questions. And what I'm really curious about, James, I want to talk to you about, but when we get down the road is, at what level is the product tested? What happens if you extract THC from a plant, you extract the CBD from a hemp plant, the THC content is below 3% in terms of the plant itself, but yet after the extraction process, you are left with a product where the THC content has now exceeded 0.3%. Because it's THC that came from hemp, is it now legal to sell that THC with a higher than 0.3% content, or is it still illegal, at least under the Farm Bill, from your perspective?
So I may create a more confusing environment for you, but I'm going to do my best. So the FDA and USDA have a very long explanation of industrial hemp, and it includes acids, which is a CBDA product. There is confusion on that calculation. It's been originally, when marijuana was originally made legal, there was a calculation that came back that was the acid times 0.877. That's been utilized by almost everyone, including us. There is some controversy over that because it depends on how it's being consumed, whether or not that acid is actually going to convert. So in a scenario where you're literally taking it as a tincture, and it is below that for Delta-9, but not the combination of Delta-9 with THCA, you're not going to get high. However, it is technically, to the FDA and the USDA, an illegal product. So that needs to be worked out with the FDA and with the USDA. The problem is all the states are treating it differently. So we're in Tennessee, where they specifically state Delta-9 only. So we have products, legal marijuana products, that come in at 29% THCA and 0.21% Delta-9, in which case it would pass as hemp in Tennessee. That's obviously a product that if it was consumed in an inhalable fashion would get you pretty high. So that's going to have to get worked out. And as the laboratory side and most of our customers, they understand that, and I think they steer clear of it. The police, on the other hand, usually follow what's taking place in that particular state. The draft regs for Florida right now include the acid form. So if you have a product that's grown and meets the below 0.3 of THC and THCA, you're going to technically pass for transportation. You'll send it to the lab and we'll test it. Let's say it's below. Once it gets into processing, you're concentrating it. It's going to technically fail for a while, but that's not a final product. So that's also something that's a little bit in the wind that none of the government agencies have effectively treated. The good news is most of the processors, not all of them, will actually mitigate the THC at that point, meaning they'll extract it out of the product and get it back down to where it becomes a legal product before it's transported and then turned into a final product. There are people that are concerned that they're trying to sell hemp flour that may be 0.32 when they test at one lab, and then it goes to a state lab that uses a different technology, GC instead of HPLC. And in that scenario, you may get some variance. Even in pharmaceutical, you're allowed to be within 20% accuracy and uncertainty. So if you're 20% off, one's 20% low and the other one's, or 10% low, the other one's 10% high, you could have two different entities saying one product's legal and the other one's not. Another issue that the government's going to have to deal with, and they haven't figured out yet. I know the state of Florida hasn't, and many of the other states haven't dealt specifically with that. But if they allow for mitigation, meaning it can't be sold as flour if it's above on anybody's scale and turned into process, it probably would solve the problem for a lot of these people.
So it sounds like, notwithstanding some relief on the federal side, we're still going to be left with a patchwork of different state laws that are going to make operations very, very challenging for folks in the CBD space or the hemp space in terms of packaging requirements, labeling requirements from state to state, and even concentration requirements. Well, Arby, let me take a step back with you, and I'd like for you to just tell us a little bit about where we are on the federal side. In other words, what happened in December of 2018? How did that affect the industry? Because you guys have obviously been operating for many years before that. And who's going to be regulating this thing?
Well, right now, as James says, it's individually in every state. Every state has its own rules and regulations, different standards, labeling, instructions. From Louisiana, Texas just passed, Greg Abbott just passed an HB 1325, which almost mirrors Florida. So the feds, I think, are really, the FDA and the USDA is kind of sitting back in my eyes. I mean, we went to their meeting 2 months ago, kind of listened to their questions. There was about 500 people there, and we're trying to figure that out. But right now, it's really the states are actually the ones that are actually taking control and putting their rules in. So that's kind of the angle that we've approached as a company. Since we manufacture, we're able to create different labels for different states, which makes it extremely complicated to get into the industry. If you're starting from the ground up or just don't have the manpower, the bandwidth to actually to do that. So we're out there, we're trying to help as many companies as we can, the good ones, because there's a lot of bad ones. Just recently, I don't know, if 2014, there's a company called Hempukas with that just got basically in trouble. She pled guilty and now looking at 40 years in jail term just because she has synthetics and spice. So again, every state is looking at this differently. I think every state has its own issues. Some states don't want to look at it all. But I think with that stage, it gives everybody an opportunity to help set the regulations across the states and watch everybody get on board. And I think at that point in time, the FDA will look and see what's working and what's working best, and then they'll come down and probably make their ruling. But today it sits, Tennessee's one thing, Texas is another, Michigan's another, New York's another. And all we're trying to do is just unify them and see that one process could work for all.
And bringing up the FDA, we've all been reading a lot about the FDA recently, specifically with respect to CBD and edible products or food products containing CBD. Tell us a little about what the FDA's position and how companies are dealing with that or reacting to that, given that, again, you might have state laws that are not consistent with the FDA's position. And then, David, I want to talk about Florida after that.
I think, again, they're putting things out there. I mean, we're dealing with them as best as we can. We're an open door policy to kind of figure this out. There's no easy pass. So it's really just completely wide open at this point, and it's really just helping with the individual states and figuring out where that's going to go. Until then, I mean, there's really the FDA is just kind of just not really, putting a lot of effort behind that. I think we have banking issues that that have to be handled. I think it being a food for us it's important. I think Florida passed that. I think there's 7 states that passed that. And I think since it's a plant, it's a food. So that's kind of the direction that we're approaching it. In Florida, now when you start making products, you have to have CGMP approval, you have to have food certification, cosmetics, and we have that. So we've acquired a company in July that now every product that we make is made in those standard facilities that basically legislated to make sure that that product is made in a certified location.
And from the FDA's perspective, because the FDA is taking the position that CBD, at least for now, is not a proper food additive, do they distinguish between any oral method of administration versus food? For example, are gummies treated differently than a tincture, an eyedropper tincture under the tongue?
Again, it really depends on the state. I mean, we lobbied, David and myself to champion that bill. We wanted to make it a food. We wanted to make it, we have tinctures, we have edibles on that. New York doesn't want that. So again, every state is a little bit different. So it's challenging across the board. You got to be really nimble. As I say, either you wear your Nikes or you wear your Adidas, but you got to be nimble, because if you're not, certain things are going to happen. We had a big issue in July where the banks and the merchants cut out a lot of companies, a lot of good companies.
And we're talking about hemp companies, not marijuana companies.
Not marijuana companies, hemp companies, and there's good companies out there that are looking to do the right thing. Yes, we have bad actors in the industry, but there's a lot of really good companies that took a beating. And I think once the rules and the FDA and the USDA and the states kind of align a little bit better, I think the industry is going to be stronger. I think we need full disclosure on our products. That's one of the reasons why we passed QR coded full panel. We got to have a full test across the board with synthetics and pesticides and solvents, and the THC levels, including THC, are under 0.3 to make sure that the consumer's first is protected. So that's very important.
So, in any nascent industry that's, will ultimately be a highly regulated industry, but the regulations we're operating in sort of a gray area right now. I agree with you that you're going to have bad actors, but as the regulations develop and the industry matures, I would imagine you'd agree with me that the sort of cream will rise to the top. The bad actors will presumably go away at that point.
It's Florida.
For the most part.
For the most part. I mean, it's Florida. It's exciting times. It's a new industry. People really want to get into it. We didn't start off in a 40,000 square foot facility. So it's not like we started off in a facility where like, whoa, let's not let... There's really good people with great ideas. And I see a couple people here in the crowd that I've actually had conversations with that have great ideas and are doing things in the industry to do it right from the ground up. So that's important, but having the rules and having a blueprint of where this industry's got to go is extremely important, because without that, then we're going to continue in the same pattern where people are getting sick. There's certain cartridges or CBD vape products or edibles that have synthetics in it. And I won't name companies, but there's a couple of them here in Florida that we've been fighting for the last 2 years. We need to protect the consumer. This is an ingestible product and a consumption product. So whether it's cannabis or CBD or hemp, it needs to be a protected product.
Right. And we'll talk about CBD vaping and THC vaping, because I think that's a very hot button issue right now. But David, tell us what's going on with hemp in Florida. Rule 1020 passed, the statute. We have a draft rule. Tell us what these rules are going to require and how things are going to change for you, particularly once the rule is ultimately adopted.
Yeah, absolutely. So the rule should be adopted imminently. I know we had a notice of final rulemaking issued, and the clock's counting. I believe the 31st is the end of that in a couple of days. So cross our fingers, nobody challenges, and we can move forward. But again, this is Florida. So we never.
I love how
we're extremely
everything bad. There's an excuse for everything bad, and we have to preface it by saying, "Well, it's Florida."
Yeah, I mean, we've seen how the MMTCs have gone. I mean, you have more licenses given out by litigation than by application. So
we could do a whole other panel.
Yeah, exactly. So we're a couple days out from having some clarity, but as Arby mentioned, it does look like it's going to be treated as a food product. All the extractors, manufacturers will have to be licensed food facilities. And really, so that the regulations spell out what's required pretty clearly. However, I think a lot of what people are missing out is that there's other underlying food regulations that are going to be sucked into this now that people aren't accounting for, like GRAS certifications are generally regarded as safe. There's no food product that can be distributed anywhere that doesn't have a GRAS cert, and that's all on companies to do it themselves. That's incumbent on companies like myself going out and getting GRAS certs for our oils and distillates and things like that so that we can distribute those. That's not a blanket policy from the FDA or a state agency. That's something that individual actors have to go out and do the research on to make sure that they're ready. So I think aside from the pretty clear black letter law that we have between the statute and the regulations, there's other areas of law between the FDA, USDA, and EPA that a lot of people aren't really considering as this goes forward. We tend to want to reinvent the wheel in the cannabis industry, but we have a lot of well-founded law in food, ag, and health policy that's not just going to get thrown out with the bathwater as we institute this new industry that people aren't really paying attention to. So I think more so than what's in the statute and the regulations is what's referenced into it, and that's not being considered is where more people are going to get hung up than what's actually in it.
Sure. With respect, you're dealing with other regulators besides just the Department of Agriculture and Consumer Services, and if you are an MMTC or a licensed medical marijuana treatment center in Florida, you're still going to have to answer to the DOH. That's something we were talking about before we started. And yes, you have to have certifications for food establishments, for kitchens, and pet food as well, right?
Absolutely, pet food is a big one, and I mean I think that's one of the where the research on CBD is probably a little better founded than some of the other industries in that. I think I talked to the Veterinarians Association, and they've done something like 60,000 administrations of CBD, one or two adverse reactions and different animal stock. And so, yeah, absolutely, that's all. And those are going to end up having their own regulations already. There's food feedstock, cattle feedstock, all these things are hyper-regulated, because anything that goes into something that's your food is going to go into you ultimately. And if you have adulterants or other things in your CBD that aren't being caught for veterinary administration, it's ultimately going to come back to the consumer. And especially when we talk about something that's really a wellness product where, again, we're getting back to what Arby said, it's about the consumer. And when the greatest number of people are taking this might be immunocompromised or have other issues, there really does need to be a heightened standard for what's going into this.
Oh, I couldn't agree more. And again, you people seem to want to default and say, oh, there's a Florida statute, let's just follow the Florida statute, we'll be fine. But that's absolutely not the case, because you're dealing with, on the state side, you're dealing with a bunch of regulatory entities, and then you're dealing with federal entities as well. Because if you're going to be transporting across borders, you're going to have to deal with U.S. Customs and Border Patrol. You're going to have to deal with the USDA. You're going to have to deal with the FDA. If you're advertising, you're going to have to deal with the FTC. So one important takeaway is it's just not that simple. In any highly regulated industry, and this one in particular, because I think everybody is watching, and that's why, unfortunately, it's so critical to have good professionals and folks who knew what they're doing, and unfortunately why you guys probably have to spend so much money on legal teams dealing with this stuff.
6 in-house attorneys.
Yes, well, the cost of doing business, just like everything else in this space, is a high cost of doing business.
And to put it in perspective, we accredit the FDA agencies nationwide. There's, I believe, 12 or between 12 and 14 of them. I know a couple of them are classified differently, but those are in states. So when you have the FDA, where we look at and say, what are you going to do, FDA? The FDA is on the other side. Nobody empathizes with their position, where they say, how can we set some type of precedent nationally if this isn't federally approved? We're fighting with states. Some states want it, some states don't. So they have to be careful, very careful about what they do, and understand that their budget is not what it once was, when there was a certain attorney general that didn't want cannabis or hemp anywhere around. So
You're allowed to name him.
yeah, but they're in a position where they don't want to make a decision unless they're forced to have to.
James, we talked about requirements and regulations with respect to food products and with respect to pet food. Let's talk about the new statute 1020 and the proposed new rules in terms of there are going to be very stringent testing requirements in addition to packaging and labeling requirements. Tell me what you guys are doing to get ahead of the curve, and talk to us a little bit about what those requirements are, how things are going to change once that reg gets passed.
So a lot of times the laboratory needs to be reactive, not proactive, because we have to follow regulatory rules. The current situation with, as long as it's not challenged by anyone, would create an environment. The law specifically states that the CBD has to be tested to the same stringent rules that the OMMU is doing for marijuana. So they've mapped those same testing regulations out. So the same level of pesticides that are being held within the standard, which I believe at this point in time, Florida is the strictest in the country, with 67 pesticides at extremely low limits. Number of solvents and the limits on them, everything that they've put into place within Florida essentially creates an environment where if this state's tested it, you qualify for almost every other state. New York has some unique stuff happening, but the QR code requirement, the levels that are set here would essentially have your product good to go in almost every state. Now, what's going to change is I think a lot of the laboratories are seeing what's going on with the vape situation, with labeling situations. Now, labeling right now, the laboratories usually give a simple percentage, which is difficult for consumers to understand and difficult for the industry to understand, and we've been reactive in that. So, perfect example, density is different depending on the product that you're selling. So if we tell you it's 20% CBD, that doesn't necessarily tell you how many milligrams are in that product, because if it's a sapphire base versus a glycerin base, that's a huge swing in density. So attempting in our sample request form to give options to our clients so that we can know what they actually built the product with, apply that change in density, and give more accurate information of the actual milligrams that are in the product, the final product. This is going to be required based on these new regulations because they want you to put exactly the similar situation to what takes place within pharma within 20%. And if you have a 15% swing in density and you're using 1 every time, which is what most laboratories do, you create inaccuracies. The laboratories are actually creating inaccuracies because there's a guess that takes place that consumers are unaware of, and probably half the manufacturers are unaware of. So I think that's going to change. Florida will change that, and then the rest of the states are going to be forced into that scenario of changing with it.
So the testing goes far beyond testing for THC content or CBD content. You're testing for a million other, not million, but other impurities, other chemicals, other contaminants as well. And you raised an issue just now about being able to accurately report either THC or CBD content. That has been the subject of a couple of recent lawsuits, consumer-based class action lawsuits, effectively alleging, we won't get into my position on class action attorneys, but no, I know you will. But effectively alleging that certain purveyors are selling CBD products. You might have a bottle that says 500 milligrams, but in reality, it turns out that it's 320 milligrams. Why this great disparity? Because presumably most of these products are tested and certified from the good actors, Arby. But so why this disparity between what a company that's commercializing a product says and perhaps subsequent test results that turn out to be inconsistent? Or are they inconsistent, or are people just looking at it differently?
So there's a few answers to that. There is no defined requirement for how cannabinoids are validated against the matrix for a test. So all of the laboratories attempt to create an environment where they'll test a product and they'll validate that matrix. And what I mean by matrix, it's the actual material. So flour would be a matrix. Chocolate would be a matrix. MCT oil would be a matrix. So because cannabis is so unique in that people infuse CBD and THC into pretty much everything, there's never going to be a laboratory that has a specific test for every matrix. So the way the states deal with that is they define the matrix as a group. So flour, one group. Derivative products, called concentrates in many other states, another group. And then edibles, another group. So you have to try to create a testing solution that's going to get as close as you possibly can and validate that. So that's how all the laboratories work. So what happens is we validate against, let's say, MCT oil because it's common and it's somewhere in the middle range on density. But a product comes to us made from glycerin, or a product comes to us made from safflower oil, and we're unaware of what the base product is. So we use a defined density of 1. That can create a huge swing. If another lab doesn't use that same matrix, they're going to come back with a different value. Now, we have what's called uncertainty, and we're allowed to have that uncertainty as a laboratory and as an entity, and that's usually somewhere in the 20% range. Now, that may sound like a lot to people, but your aspirin in your cupboard has that same 20% variance. And they're only dealing with one matrix because they have the same product over and over and over again. But when we get a Rice Krispie square that's been infused with CBD, this is based on the matrix that we've done internally. So we may take a Rice Krispie square that has nothing in it, infuse it, run it one time through our system so that we see what it comes back with, but many labs don't. They won't treat that as a separate matrix. They'll just use their edible matrix that maybe they use the gummy or chocolate with, and they're off by enormous amounts. So it's not necessarily always the fault of the CBD manufacturer. Sometimes it's just the inability to test all of those matrices. Now, we've done a lot of television interviews as well where people, the the news loves to bring in CBD products and show that they're all over the place. So there is bad actors, as everybody said, where there's literally zero CBD. That's impossible to be off by that much. So if someone's got zero CBD in it, that's irrelevant in matrix. They're duping the consumer. They took hemp seed oil and they told people it had CBD in it or whatever they did. This is the main problem. Those people, the ones that are actually attempting to do the math correctly and get the number correct on the bottle, they can have a 20% swing. I think these class action lawsuits are probably going after the larger players that have money, because that's what class action lawyers do, and then they're finding a product that's 15% off and saying that's a lie. It's not. If they actually went and looked at the way, there's no regulation for CBD to force it at 20%, but that's what the pharmaceutical grade uses, and food grade.
Sure. So Arby and David, how do companies like yours deal with these type of consumer complaints that, I won't get into who may be driving them, but you find yourself in a situation where these cases may be incredibly difficult to prosecute for the reason that you articulated, but it may be incredibly difficult to defend for the very same reason. How do you deal with this as a company, whomever?
Yeah, for one thing, on our side, where we're more upstream than the product manufacturers, there needs to be distinct grades and qualities of inputs with crude oil, distillate, and these things, where you look at the oil and gas industry, they have anchor measurements with sulfur and these other things, so you have a distinct quality and grade of an input. We don't have that in the industry. We have a lot of spot buying in broken up supply chains where a purchaser will buy crude oil based off a small test, and then you get the whole batch, and there's a huge variance in the quality consistency. So you make your measurements off of the first one, and then back in you make 10,000 gummy bears, and the first batch may have been made with the oil you tested, and everything else has tremendous variance in it. So it starts with standardizing the supply chain and standardizing the inputs. So that's step one, is you got to have high quality input. That'll help mitigate a lot of the variance in testing and those things. And that's more from my perspective on the front end, upstream side. I think Arby would probably have a better perspective on how they can mitigate it within the actual product manufacturing and then through to the end-to-end product.
That's a great point. It starts from there. So I think that's where the rules and regulations are going to determine how the finished good comes out, whether it's the farming and extraction, the testing all the way across from the seed to the manufacturing facility, across the board. We're going through a class action right now. 2 people. One is my partner's neighbor. We went back, and obviously I can't get too in depth with the case, but the fact is that one of them was the 20% variance. Another one was used a lab, because we're full transparency. Our batches, our full labs are on our webpage from 2018, from a batch that we did in the summer of 2018. So again, we understand the issue. There's good people in this industry, and the manufacturing is not something that everybody understands exactly what they're doing just yet. You do have different types of formulations. You have different types of raw material. You have from distillates to crude to everything across the board. So you're trying to do the best that you can by sending it to a lab, getting we have something where we might send 25 kilograms to the lab and say spot test to 25. We'll put our money in escrow if these 25 pass, and then we'll buy it at that point. I think that's really the direction it's going to go until there's some kind of clear path to knowing that when you're purchasing something, that you can consistently know that what you're getting is exactly what you're paying for.
So it's going to be interesting to watch this thing unfold, and I think that guys like Gary and James are going to become expert witnesses before they know it. So let's talk a little bit, and James, you touched upon it, let's talk a little bit about the vaping crisis. Gary or James, I think you guys are probably in the best position, at least among the 5 of us, to talk about what at least the wisdom today is in terms of what's causing the vaping crisis. We're hearing first it started that it was more of a CBD issue. Now I'm hearing it's typically the problem is arising from black market THC cartridges. What are you guys finding on the testing front, and how are you dealing with it?
I'll jump in for the first 30 seconds. From an accreditation standpoint, I've always been leery about the new product out there, and what's tested and what the requirement is for those products. The problem is when you have dishonest people out there peddling product that isn't tested properly, you can end up with anything. Back before California regulated that every piece of product had to be tested on the shelf for cannabis, you had labs out, or you had dispensaries selling products that weren't tested. And there was a mad shuffle to get the product tested. I would never have anything in my body that wasn't tested. There's too much out there that if it's not tested, you don't know what happens. So were people injecting things into these vape cartridges? They very well could. I don't know if I'd buy if somebody gave me an answer and they were one of the people who said, yeah, I took this and this problem happened to me. Well, they may be the dishonest person. So there's really no way to do that. There's repeatability, and in the testing world, you establish a baseline and you have a reference sample that you can base everything from. But if you don't know what happened to that product, because the chain of custody is broken once that consumer gets it, there's a problem there. So you're dealing with an unknown. And that's my perspective. I told people, listen, if there's a problem out there and something's detected like a vitamin E or hydrogen cyanide from aflatoxins and fungicides that are in there, or too many pesticides, you can get other dangerous chemicals from the flash points of those if they're smoked. There's all sorts of issues if it's not controlled, and these things are traceable. So I'll let James take over with his viewpoint.
So if you read enough about what's going on with the vape crisis, you're going to get someone with the opinion that says it's vitamin E acetate. There's going to be others that are saying it's the cadmium from Chinese vape pens. There's going to be people that are saying it's heavy metals that aren't being tested for, like nickel. There's opinions on a lot of things, and the CDC and others haven't 100% confirmed any of this. So on the laboratory side, many laboratories are already validating methods and putting out testing results for vitamin E acetate. But we're trying to take it a little further. We're actually next month going to have a full lipid panel, because there's absolutely no proof that it's not some other lipid that's causing it. And what I mean by that, it's the reason they're saying vitamin E is the problem is because it's a fat that when you vaporize it, it goes into your lungs and then turns back into that liquid fat, interferes with the mucus in your lungs, and then causes you to get a type of pneumonia. That's just an opinion, but there are other lipids that are available to be cutting agents within vape pens, so we're going to go do a full lipid panel and try to get ahead of that curve. And then we've added a bunch of heavy metals to our panels that will allow our customers to add to their COAs as well, and try to create an environment where, when and if it ever is confirmed what the problem is, they can have a COA that says, vape free or vape safe or whatever they're going to attempt to put on that. But that is a reaction that we're trying to be proactive against, but there's no direct proof on any of this yet. So we're going to try to get ahead of it, and other labs are as well. I've seen numerous labs making claims of vitamin E acetate, but I would assume that they're going to be going down the same path as we are, trying to test for more and more things that could be a carcinogen.
We don't know yet. I mean, is the short answer. So everybody is trying to be as diligent as possible, and understandably, both more state than federal regulators are trying to jump ahead of the issue, and they have been perhaps overzealous. And I'll put this to Arby and David. In terms of issuing subpoenas, I know that we've been dealing with responding to AG subpoenas in various states for clients that sell vape cartridges, either THC or CBD cartridges, bans on flavors, overall outright bans on vaping in general. Do you think that this is an overreaction on the part of regulators? How are you guys dealing with it, and how is it affecting your bottom line?
For us, I mean, that's the reason why rules and protecting the consumers is so important. You need to be able to disclose what's in the product. So what we've seen is a lot of companies use either hemp or CBD as an advertising tool to be able to deliver these products to consumers when there's really maybe no CBD in there. You don't know what's in there. It's affected a lot of small businesses that we're reaching out to and actually kind of converting them from a vape standard almost to like a natural store CBD and providing them other CBD products to sell. So we've seen a huge impact, not for us. I mean, for us, it's been somewhat, we don't really sell a lot of vape carts, but the consumers, the small stores, the retail stores are the ones that are suffering the most. And really, they've been the one that's been able to educate our consumers on what CBD is, or they've worked with us 3 or 4 years in the pamphlets and the educational side. So we want to make sure that they're successful. So we're trying to figure out exactly what the best possibilities are. And really, it's labs like James and Kaycha, and looking at all these testings and all these directions. It's a new industry. So there's so many new things happening, and there's so many obstacles in the industry. But we're here to make sure that whatever we need to do in reference to research with universities, working with the states, traveling to Nebraska. We've been to Nebraska. We've fought certain states that didn't want hemp or CBD in there. South Dakota, we got a letter from the Attorney General there allowing our products to be sold there because we had no THC. Why are they not following federal guidelines? We don't know, but that's a decision they made. So again, the industry's so wide open that there's going to be some standards, and I think really at the end it's going to be the testing facilities that are going to really dictate and help the states say, hey, this is where the issues are happening. Let's make sure that this doesn't happen again.
So it sounds to me like, notwithstanding the fact that it's probably extremely cumbersome in the short term in terms of expense and trying to get the products to market, that more and more regulation, again, while one's natural inclination would be, I'm in the industry, I'd rather it not be regulated. It sounds like there's a consensus among this panel that we want regulation.
We don't want
this,
over-regulation.
But we want
so
it to
so
be
there's
a highly regulated
there's a
industry.
difference. So again, regulations is one thing. Being over-regulated is another.
Right.
You know, there's got to be on the cannabis side. I mean, I was in the cannabis industry from '08. You know, so you kind of saw where that panel and you know what the states or the counties or cities were doing in Colorado. You don't want over-regulations. You want opportunities, because when you over-regulate, you're kind of limiting the innovation in the industry. But you need something that gives us a floor plan to follow. Because if we don't have that, you're just going to continue to have issues and products that come out that have no standards. So Florida for us, we want Florida to be the diamond of the country, basically. Food certification, CGMP, food certified, have all the capabilities from manufacturing, from what David's doing, all the way to us grabbing the product, getting the raw and turning it into a finished good. That's what needs to be regulated. It's not over-regulation. It's just giving us some type of that we can follow, because right now we don't know if we do something right or wrong. So then we got to go backwards and spend the money on the attorneys, as you know, are very expensive. You come from an amazing firm, and we know that it's
I work for free.
Yeah, so we know that it's expensive to kind of go back to the state and then have these lobbying fees and all these other things going on in our lives. At the same time, you're trying to build a business and you're trying to provide to your consumers a good, clean product. We've been working with James and Chris, and when we first started with them, it's not cheap to send out a product to get full panel tested. And they don't work for free. So between lobbying, attorneys,
I've been
and
to his
paying
lab,
for
by the
labs,
way. There's a lot of money into that lab.
I mean, I look at our bottom line and I'm like, those are 3 very expensive bottom lines, but we have to do it. And
Right.
somebody needs to do it to make sure that the industry continues to move forward. And I feel that Green Roads and a couple others have basically laid on the sword to kind of drive that generation and make sure that we're not over-regulated, but that we have some kind of standards in the industry.
Right. And by the way, it's nice to see, particularly in such a nascent industry, so many industry drivers coming out of the state of Florida. We get such a bad rap, but look at this panel. That fear of overregulation leads me into probably my last question, and then we'll try to take a couple questions. But for David, what about the proposed hemp rule in Florida scares the crap out of you? Because we're talking about the good stuff. There's got to be something that scares you in there.
I mean, yeah, there's quite a few things that are troublesome. more so probably from the agricultural standpoint, where they're putting in definitions of plots and how to move plants around it, and certain things that are going to necessarily inhibit genetic purity and consistency through nursery operations and other things, which is kind of what, getting back to the last question, is we to mitigate some of these fears, we have to have best management practices consistently, so we can be transparent about the product we're delivering, so that we know there's no heavy metals, pesticides, or any of these other adulterants in it. And a lot of the agricultural practices make that difficult in what we're doing, and how to regulate it, and how to move it, or are stifling the ability to do R&D. And it's a fine line between fair regulation and over-regulation, and you can't say you don't want regulation, because a free market is a fair market, and you can't do that without guidelines. But there's a lot of stuff that's touch and go, and as soon as we have problems, the inherent reaction on the government side is to overreact. I mean, we have thousands of homeless people dying a day in LA, but then they ban vape products for 3 deaths. We have how many traffic accidents a day, and how many people die of heart disease because of sugar, and about 13 vape incidents, and all of a sudden it's a crisis. So you have to be very careful with the regulated industry. So I don't think it's a single one, but I think it's the totality of it, and where there are some pain points, it can inherently lead to that snap reaction by the regulators to do something. I know we've fought several times. I mean, there's been rumors after rumors that they're going to snatch all the CBD products off the market, and for everything, they're going to put all-out bans on cultivation and certain practices, fungicides that have been approved. So we've seen it state by state in other places, and that is the big worry, is that there's not just one, but a few of those points where anything goes awry, and then someone blames it on that, and then all of a sudden we're stuck in a regulatory nightmare for years to come.
And to go on that, when we passed for the hemp bill and we went to Florida to legislate in 2017, there was a law that was bipartisan for June 30th to make CBD illegal. So prior to us going up there, there was a bill to ban, due to vaping and other consumables, but there was an actual senator that actually had bipartisan to make CBD illegal in the state. So we've seen that, so that's where we need to be very fearful on how they react, or one signature kills the industry. So that's always been our biggest fear, is having a legislator, somebody just with one stroke of a pen said, you know what, let's just wait and overlook at this, and the next thing you know, we're 2 years out of this industry, and the industry's not moving forward. So the quicker that we have some kind of guidance, let's not use the word regulation, but guidance, I think it's a big win for the industry.
I agree. I don't know if we have time for a couple of quick questions. There was so much we didn't cover. We didn't even talk about the industrial uses of hemp above and beyond CBD, but and I think we're already running late. But if anybody has anything that we could address quickly, I'm happy to. Okay, with that, let me thank the panel.
Easy.
Oh, we got one.
Sorry. Do I need to come up here?
I can hear you.
Okay, great. So I think that you were saying that THCA in certain percentages is going to be illegal, so that if you're looking at raw flower or hemp flower, that's showing up at a high percentage of THCA, but like 0 and Delta 9, is that going to be something that's illegal?
In Florida, the combination of, good question, but yes, in this state, the combination of THCA and Delta 9 over 0.3 will make it an illegal product, if I'm not mistaken. So that is something that actually is going to be in the rulemaking, where any combination of THC over the 0.3 will make it illegal.
I know that sounds like it's a tough thing for hemp flower, but we get, I would say most of the hemp flower we receive, when you take THC, Delta 9 THC and THCA, it does pass for under 0.3. There's some that comes in hot, of course, because they used genetics that was too close to that, or the way that they grew the product, or the way that they cured the product, the more it's dried. This is dry weight as well, so once it's dried all the way down, sometimes as a wet weight they think it passed, as a dry weight it fails. But realize the problem for the regulators, and it's just an unfixable problem. Again, we have product that comes in every day that's 29% THCA and 0.2% Delta 9. So if you're going to say it's Delta 9 only, that's going to qualify as hemp, and that 100% in anybody's eyes is marijuana. So what are they going to do? They're stuck. So a lot of people are trying to convince them to go all the way to 0.8 because that was a definition of low THC in many of the states. But the federal government already has definitions on their website, so it's going to be tough to go by that.
And it kind of creates a weird ambiguity too. So our company has operations in Colombia, and we're at a 1% threshold for total THC, and it's still easier for us to bring that into the country than it is for us to get some flexibility in testing here. So I think we still have some work to do as far as that threshold at the federal level. I think that's one of the next iterations of the industry is to push for a 1% threshold here domestically, just because the pharma kinetics behind 1% THC don't make a difference between 0.3 and 1%. It's kind of an arbitrary number that got put on it just to bring hemp back into the legal space in 2014. So we have some work to do there, and maybe some smarter regulation at the state and other levels, more like Tennessee, where instead of a total THC cap, maybe we have a cap on the Delta 9 or the acids, so that we're not taking advantage of it, growing 30% THC that's going to get you stoned to bejesus, but something that's within a reasonable range for the conversion.
I do have one more question, and it's about testing, if you don't mind. I have a product that I've tested with 3 different companies, all here in the state and here at this convention, and there's been a marginal difference, like 100 milligrams between all 3. So is that going to put me over, like if I'm advertising, let's say, 500 milligrams, and one of them is coming back at 620, the other one's coming back at 550, the other one's coming back at 510. Where am I legally required to participate and make sure that I am not mislabeling my product?
So if you label that at 500 and you have a 20% variance, you'd be able to go 100 in either direction, and most of those labs would have passed. So I would ask the labs that you're sending it to please do a density verification against the product and then put a label validation on your COA. So specifically, instead of saying milligrams per gram or percentage, ask them for a specific amount for your final product. So if you want it to be a 500 milligram product, ask them to verify that that's truly 500 or 490 or 470 or 530 or whatever it is, and make sure it's within that 20% variance, and then you're fine.
Okay, thank you.
I think we got to wrap it up. Let me
Make sure you're using an accredited ISO.
always,
Always.
always. Thank you very much.
Remind me.
Extremely knowledgeable panel. I'm sure these guys will be around if you have any questions. I will be as well. Thank you all.